Namaskar, hello and welcome viewers. You're watching this special presentation of Sansad TV, Bills and Insight, your one-stop destination for views, news and analysis of proposed legislations of India that have far-reaching implications and impact your life. I'm your host KRITI MISHRA, and today the spotlight is on the Tribunal Reforms Act. It seeks to dissolve certain appellate bodies and transfer their functions to other existing judicial bodies. Before the detailed analysis, let's take a look at the highlights. The Finance Act 2017 merged tribunals based on domain. The Act removes these provisions from the Finance Act 2017. The chairperson and members of the tribunals will be appointed by the central government on the recommendation of a search-cum-selection committee. It specifies a minimum age requirement of 50 years for appointment of a chairperson or a member. So why did we need this legislation? Well, the term tribunal is derived from the word tribunes, which means magistrates of the classical Roman Republic. Tribunal is a quasi-judicial institution that is set up to deal with problems such as resolving administrative or tax-related disputes. While introducing the bill, the central government stated that as per the recent data, the presence of tribunals in certain sectors has not led to faster adjudication. Such tribunals add considerable cost to the exchequer, and abolishing them would help in reducing these costs. The Act abolishes 9 existing appellate bodies and transfers their functions mainly to the High Courts. And for deeper insights on this Act, I'm joined by an illustrious panel. Joining us through virtual platform, Dr. PATNAIK, Member of Parliament from the BJD. In the studio, we have with us Dr. VAGESHWARI DESWAL, Professor, Faculty of Law, University of Delhi. And also joining us, Justice S.N. DHINGRA, former Judge, Delhi High Court. And in the studio, we also have with us young and vibrant audience. I welcome all of you on Sansad TV and thank you so much for being with us. And before we commence our discussion, let's take a look at how this bill was passed in Parliament.
Justice, by reducing another layer of litigation, it will bring in bureaucratic efficiency and finally it will bring uniformity to the terms and conditions of the members.
Through the second schedule, the government wants to remove certain tribunals, which is in fact is going to increase the burden of the high courts.
कमेटी के 74वां रिपोर्ट में है कि इसकी अवधि 7 वर्ष होनी चाहिए। मैं इसका सपोर्ट करता हूं और दूसरी बात नेशनल ट्रिब्यूनल कमीशन तैयार होना चाहिए।
Appoint for 5 years, and we say no. In order to have a better, efficient management of the tribunal, we want members to be there only for 4 years and not 5 years. Is there a constitutional question in that? 5 years versus 4 years.
And Justice DHINGRA, let me begin the program with you. According to you, what is the need for reform and rationalization of tribunals in the country?
See, reforms and rationalization has to be a continuous process. It should be in all fields, not only in case of tribunals. I consider reforms are badly needed even in judiciary. So, if the government has made an attempt, brought a bill to reform the tribunals, I think that is reasonable and justifiable. Now, what the government has done is to merge some of the tribunals with others and to assign the work of some of the tribunals to others. See, what we are having different acts in which there is a provision that in case of, you are not satisfied from the order of the authority, you can approach the tribunal. Now, there are authorities like Cinematographic Act,
Yes.
then Customs, then we have Highway Authority of India, and any dispute from these authorities' decisions go to tribunal. In many cases, you see the tribunals are appointed, they don't have sufficient work. So in case of Cinematographic Act, you may have 3 cases in a year, or 10 cases in a year, or 1 case in a month. Now, for 1 case, you are created a great paraphernalia. When you appoint a tribunal, you appoint chairman, members, reader of the court, because it is just like Acts court, stenographers, PNs, record keeper. And you see, for one judge, I know at least 10 persons are appointed.
Yes.
Then you have to provide all facilities to each member. You have to provide car, you have to provide free petrol, you have to provide driver, you have to provide house, you have to provide, all those things are to be provided. And in most of the cases, when you have no work, you are sitting with all these perks. And I have also personal experience of seeing the members of tribunal simultaneously doing arbitration. See, they are getting full pay from the tribunal. They have no work. Even if they have work, they do arbitration. And the fee which is charged from the arbitrator is exorbitant. You cannot imagine how much fee is charged by the arbitrators. Therefore, I feel that it was very necessary that those tribunals which were not having sufficient work, they should have been merged, and this is what the government has done. Reforms was called for long back, but since our executive and parliament is much weaker than the judiciary, they always treat the path of reforms very slowly and hesitantly and in a very. I think it is a right step which has been taken.
All right, it is a right step, but you made certain very important points, sir. Let me take that to Dr. Patnaik. Dr. Patnaik, Justice Dhingra just said that reform is a continuous process, and he also said that probably legislature, the pace of reform, that is a little slow, and also the fact that he says that we need to reduce the cost. What is your take on that?
No, I entirely agree with Justice Dhingra. Because you see, the tribunals were not initially part of the constitutional scheme of things. They came in through the 42nd Amendment, 1976, and primarily through those two amendments, 323A and B, but primarily to address the issues of administrative matters and tax reform. So I do not know how a Cinematographer's Act appellate body again had the reason for making a tribunal. All these infirmities that had crept into the entire ecosystem and making therefore costs prohibitively expensive for the country as a whole, the reforms were necessary. The fact that this process actually is not even 2017, it started in 2014. And again, it was replaced by this 2017 ordinance, a bill, then an ordinance, then the Supreme Court comes in. So the process took longer. But I know if the judiciary would have stepped in, it could have actually become faster. But in this case, actually, the judiciary struck down the ordinance on many aspects, and
Yes.
it had legislated afresh as a bill and has been passed as an act.
Professor DESWAL, while this bill was discussed, one of the concerns that was flagged by the members was that there won't be specialized courts, and that would be detrimental to decision making. Would you agree? Would you disagree?
I would partially agree and partially disagree. Because when we brought in this concept of tribunals, the focus was on specialized forums, which would move away from the technicalities and formalistic procedures that were followed by our courts, so that we could provide cheap as well as expeditious justice dispensation to our people. And that was the reason why we had these tribunals in the first place. But then, as Justice Dhingra said, that we had certain tribunals whose workload was very, very less.
Yes.
So having the entire paraphernalia, a judge, his staff, and the entire infrastructure for just 3 or 4 cases in an year, I mean, that is, we cannot say that there is a balance of sorts. So what we need to do is, now the step that has been taken by this Judicial Reforms Act, by this Tribunal Reforms Act, is that many tribunals, they have been merged, and for many tribunals, their workload, it has been transferred to the existing high courts.
Yes.
So wherever required, maybe we can bring in a technical expert who has a specific domain knowledge. We can take some inputs from that person, and that way there can be a significant cost cutting in that aspect.
Right, a significant cost cutting, but Justice Dhingra, we also have to talk about pendency of cases. Now, these cases would be transferred to commercial courts or to the high courts. And as we speak, by September 2021, 56 lakh cases were pending in the high courts. Won't that add to pendency of cases?
See, I totally disagree with you. We have pendency of cases not because, you see, people are rushing to courts. We have pendency of cases because our courts are bent upon deciding the cases in a protected manner. See, at the drop of hat, you get an adjournment. The advocate's stomach is not well, you get an adjournment. His tooth is paining, you get adjournment. He has personal work, you get adjournment. And I was surprised to see the other day that one Supreme Court judge called many cases, none appeared. Then he told the court master, I am going, when somebody comes, you please call me. See, if this is the attitude of judges, how can you dispose of cases? See, I have been judge for about 27 years.
Yes, sir.
I had made it a point that no case will last before me for more than 1 year. And I saw to it, even as trial court judge, even as high court judge. So you have to change your attitude. You cannot show your brotherhood to your brother advocates from the stream which you have come. And say, once I was an advocate, I used to seek adjournment. Now I will give adjournments freely. See, unfortunately, we are not following the law even in this case. The law states you cannot give more than 3 adjournments to a party, either side. You cannot show me a single case in which it has been rested with 3 adjournments. You will find up to 30 adjournments being given. So we cannot blame this, you see, the law for delays. And then you must have seen that whenever there is some emergency arises, these very judges, and you see, rise at 12 in midnight, sit late in the evening, work on vacation. Why? Because there is an emergency. And what is the emergency? It is not for common man, unfortunately. Emergency is always for the rich and for powerful people. So this excuse of pendency of cases and number of cases is, see, pendency is there, no doubt. But this excuse should not be taken because we are responsible for the pendency. All
right, I think that's a very, very valid point that you're making, sir. And let me take that to Dr. PATNAIK. Dr. PATNAIK, you may recall that when this bill was discussed in Parliament, pendency was the biggest issue that was flagged by almost all sides. But Justice Dhingra here says that pendency is a larger issue, and let's not say that this particular Reform Act will add to the pendency of cases in the High Courts. Your take on that?
See, Kriti, ironically, the pendency is one of the major reasons for abolition of the tribunals and transferring the matter to the High Courts, because just as Justice Dhingra said, getting adjournments from the tribunals is even easier.
Yes.
And besides the fact that some of these tribunals never had any work. But if you take a look at a tribunal like the National Green Tribunal, it has lots of work. And I know that currently the adjournments are not being given there. So, it all depends on the judge. And I would go further to say that Indian judicial system has to take a call on this. It is not just the judges, it is the lawyers. It is lawyers like us who have to take a call that protracting a case and taking adjournments rather than finishing a case is more important as a contribution to the judicial system and people's trust in the system. So therefore, pendency is the reason for transferring it to the High Court and Supreme Court. Of course, there is a case that the procedure for appointment of judges in the High Court and the Supreme Court has to be made much more faster, which has happened, fortunately, during the tenure of the current CJI. And the government and the Supreme Court Collegium has to work in tandem. So the 40% vacancy, which was there when I remember I spoke about this in the Parliament, has now been reduced substantially. But this process has to take place in a very automated fashion, so that the judges are there in the High Courts and in this Supreme Court to listen to these cases, because some cases will get added. So I think, the role of everyone in the system, that is the lawyers, advocates, and the judges and the government of India, is very crucial in improving the system all around.
All right, these are structural problems that have to be addressed, but talking about another important aspect of the Act, that this legislation also provides for uniform terms and conditions of services for chairperson and members of various tribunals. Professor DESWAL, will this lead to stability in the tribunals?
This is a very contentious issue, because this is talking about a 4-year term, which is directly in contravention to what the Supreme Court had suggested, that we should have a minimum 5-year term to bring in more stability, that the chairperson as well as the members, and especially since those people who are not judicial members, now they need some time to acquire this judicial acumen. And if we are going to give them these short terms, and unless and until there is a security of the renewal of their term, so it is highly questionable how much time and energies the members would be putting in their roles. And of course, that would also increase executive interference in the process of appointments and reappointments of those members. So here this is slightly contentious because one, it is directly overriding what the court has said, and that is also one of the reasons why the Supreme Court seems slighted, because when the court had overridden, had expressly struck down certain provisions of the ordinance on the grounds of their being unconstitutional. But when we got this Tribunal Reforms Act finally in August, it seemed as if the union had stung back by bringing in those same provisions, which the court was specifically against.
I think Justice Dhingra can throw light on that, sir.
See, I totally disagree with Professor DESWAL. See, we are appointing Supreme Court judges at the age of 61, 62, 60. Some of them get 3 years in the Supreme Court, some of them get 4 years, some of them get 5 years. Lucky one gets 6 years. Those who are lucky enough to do this. If a Supreme Court judge can have 4-year tenure or 3-year tenure, I don't understand why tribunal cannot have 4 years.
Okay.
We have appointed High Court judges in High Court at the age of 59, remaining only 3 years, because retirement age in 62 is 62 in High Court. High Court judges I am talking, they are appointed out of advocate with no experience of a judge. Some of them are appointed who had not been even properly, you cannot call them advocate also. They were just putting stamps. Both commissioner. So, if you can appoint judges at that age, then how you cannot appoint with 4-year tenure or 5-year tenure? What is the hitch in appointing tribunal for 4 years? If you have 5 years, I don't know what additional advantage you will get in 1 year. You can have, see, somebody who wants to work, he will work even in 4 years. Somebody who doesn't want to work, you appoint him for 10 years, he will not work.
Never work.
I have seen it practically in courts. Those who work. Now, as far as you see, Supreme Court objection is concerned, I think Supreme Court had not considered this prior to. And age is concerned, age of 50. See, we must have minimum age for appointments.
Right.
Even for appointment as additional district and session judge, directly district judge, there is minimum age of 35 years.
Right.
And 7-year experience you need as advocate. So you become eligible at the age of 29 years. But you are not appointed additional district and session judge or district judge and session judge at the age of, you can't be appointed, age of 29 years.
Right.
Because there is a bar of 35 years. Why this bar? Because you need to attain a certain level of maturity.
Maturity. Right.
And once you sit there, you are faced with such advocates who have a long experience. If you do not have that much experience and that much maturity, you cannot face the way, you cannot face Kapil Sibal, you cannot face these people
Right.
who have throughout their life been, you see, jumping upon the judges, how to get favorable.
All right, sir. Okay, Dr. PATNAIK, I could see that you wanted to make a point. Please go ahead. The floor is yours.
One point, of course, I agree completely with Justice Dhingra. One point I want to make, which the professor made regarding the Supreme Court thought to be getting slighted. But the point is, the law is to be made by the Parliament. The debates are to be held in Parliament. Whatever Justice Dhingra discussed here is to be discussed in the Parliament. The courts are not going to make the law. Parliament is supreme in making law. So that is to be established. Number two, I think if you look at other constitutional bodies, you look at the CAG, he also has to be independent. The Chief Election Commissioner, he has to be independent. And the independence of these constitutional bodies has already been established. But we have had Chief Election Commissioners for 1 year, 2 years. But the system or the institution has proven to be completely independent, fair, just and transparent. So I don't think how making 5 years as a sacrosanct principle by the Supreme Court holds good at all. Actually defies logic.
Absolutely. And as Justice Dhingra said that if you have to work, you'll work in 4 years. And if you don't have to work, you'll not work in your entire life. On that note, let's also take some questions from our audience here. Please go ahead, introduce yourself and speak your mind.
When the tribunals were established, the purpose was to lower the burden and the pendency of cases that are there with the high courts, like Delhi high courts. Like around 13,000 cases are pending for over 10 years, and around 20,000 cases are for more than 5 to 10 years. Then what was the point of transferring the matters back to the high court when they are already burdened with the existing case loads?
Justice Dhingra.
You see, the purpose of constituting tribunal was that tribunals will decide it in expeditious manner. Now, unfortunately, we thought only judges can head the tribunals. And we send High Court judges and Supreme Court judges to the tribunal to chair the judge. These judges cannot get rid of that sluggish procedure which they follow in the court. And they cannot get rid of that mindset that they are now content with their work already done. This is time of their retirement and they have come to enjoy. So that mindset, so long as that mindset remains, in the tribunal, no, the pace of work is so slow.
Yes.
That you get first hearing after 6 months or 9 months. So, at least in the court, you see, there, as in the court, you see, you get first hearing depending on the pendency. So, why not to have better opportunity in the court, and then you can have more judges in the courts.
Right.
There will be continuity.
Absolutely.
You can increase the strength of judges in the court. And one thing more I want to emphasize is, time has come that we should have specialized courts. Within the High Court, as we have, you see, commercial court bill, we should have specialized courts, that these courts will do only civil matters, these courts will do only criminal matters. Then you will save enormous time, because the judge will not have to learn every time the new law.
Can we expect the fast disposal of cases where the cases will be transferred like to other courts? And my another question is that in our country there are many bodies in which we can find drawbacks. So dissolution of tribunal is only the option, or other alternatives could be found from this?
See, other alternative I have already told that we need to create specialized courts. In the specialized courts, there will be much faster disposition of cases, because the judge will not have to understand law from the advocates. Today, the situation is roster of High Court changes after every 6 weeks,
Right.
6 months. In some of the High Courts, the roster changes after 6 weeks. and a person, advocate who has practiced throughout his life taxation, he is made High Court judge and given civil branch
True.
or criminal branch. See, he takes 6 months in understanding what is criminal law. By that time his roster is changed. So we need to have specialized courts, and tribunals are also not specialized, because we appoint the same very judges to the tribunals. We don't appoint people with special qualification, except with those 2 persons who are members.
Members, yes.
And most of the time members are overruled by the judge. I know more than what you know.
Right, sir. On that note, I'm completely out of time on the show, and we also know that Supreme Court will decide on the constitutional validity of Tribunal Reforms Act. But for now, it's a wrap from my side. Thanks so much for joining us, Dr. PATNAIK, Justice DHINGRA and Dr. DESWAL. Next week, we'll return with incisive analysis of another important bill. Till then, take care and stay tuned to Sansad TV. Namaskar.